Hello, everyone, and welcome. We are so excited you were able to join us for tonight's webinar on Planning for the Future, a Roadmap. My name is Siobhán Alvarez, and I am the Executive Director of the Atlanta Autism Consortium. If this is your first AAC event, welcome. We are so glad that you guys are here tonight. We are a nonprofit organization dedicated to creating connections throughout the Metro Atlanta autism community. We host free programs and events every month, and we aim to serve the spectrum at large, including parents and family members, adults with autism, researchers, clinicians, and educators. While our events are usually in person, due to the need for social distancing right now, we are excited to be able to continue to be of service through webinars like this. A few things before we get started. Please know that your microphone will remain muted, but you can feel free to ask any questions throughout the event by typing them into the chat box, which is located at the bottom of your screen. I will be monitoring this chat box, so feel free to ask these questions as we go. We'll be saving time at the end of the presentation for a Q&A with our panelists. Tonight, we'll be talking about planning for the future of your child with special needs, and we are joined by panelists Laura Akins, an attorney with Nadler Biernath, and a financial planner, Scott Jeffries of Northwest Mutual. About Laura. Laura is an attorney with Nadler Biernath and practices in the areas of elder law, probate, and estate planning. Laura assists her clients in planning for family emergencies, finding solutions for complicated mixed family circumstances, and for the end of life. And her firm actually specializes in special needs individuals and senior citizens. And as for Scott, Scott is a wealth management advisor with Northwestern Mutual. He is a member of Northwestern Mutual's Special Steps program and has received the Chartered Special Needs Consultant designation. As the parent of a child with special needs himself, he is experienced in special needs planning, including navigating third-party benefits and the legal issues involved with planning for a dependent with special needs. All right, Laura and Scott, thank you so much for joining us tonight.
Sure.
Glad to be here.
So Siobhán, it's not letting me share my screen. It says that when I try to click on it, it says that it's been disabled for participant screen sharing.
Are you logged in as the panelist?
I clicked on the panelist link in the email.
That is so interesting. Let's try to troubleshoot this. Okay, Laura, are you able to do it now?
Let's see. Yes.
Okay.
Here we go.
No problem.
Okay, so let's set it up so it's as a slideshow, and I'll just go ahead and get started. Does it sound good to you, Siobhán?
That sounds great to me.
Okay, so just so you kind of see who's talking here, we've got a picture, and as stated, I'm with Nadler Biernath. We are a full-service estate planning firm, but we have the niche in special needs planning and elder law, and we're really happy to be able to serve that community in Atlanta because not too many lawyers do, and we really enjoy it and appreciate that we've got this specialty. So, you know, just like any lawyer, they always give the caveat of the fact that this is not actual legal advice, anything that you hear tonight, and instead we're here for educational purposes and just general information. Just a little background with Nadler Biernath. We have 3 attorneys in the office, and we have several years of just kind of very focused special needs experience. So that makes us a little different and able to speak on some of these things on an expert level. So we're talking tonight about a roadmap for the future, which can really look like a lot of different things, can manifest in a lot of different ways. But one of the things that we often use is a special needs trust. And people are always wondering kind of what is special needs planning? What does that really even look like? So for us, special needs planning really means that we're planning for families who have a child with a disability or another family member with a disability or a disabled person themselves, and we're planning for benefits. So we're either looking to create eligibility, preserve eligibility, or maintain eligibility for a disabled person so that they can take advantage of public benefits which can be, as I'm sure many of you know, they can be very, very useful. But the person can also maximize assets that are available to them through their family or their work or other means. The primary mechanism that we do this planning with is by creating special needs trusts. And I'll talk a little bit more later about kind of how special needs trusts really work and what's involved in doing a special needs trust. But it's important to remember that when we're talking about planning to preserve assets, we're not trying to circumvent the system. We're not trying to, take advantage of the system, but instead we're trying to provide for a person who has usually pretty high expenses, especially as they age. It can be very expensive to have a disability, and benefits are pretty minimal. If you can get some of the good ones in Georgia, it can be amazing. But usually if you need the good ones in Georgia, that's because you have a high level of need, and so your expenses go up. So when we talk about special needs planning, we're not talking about circumventing the system. We're talking about preserving assets that can supplement and really provide for a higher quality of life than if a person was just relying on just the benefits or just assets that their family has. Okay, so before we talk about a special needs trust or different planning techniques, we have to talk about what benefits are actually available to a person and what kinds of things are we planning for. We got to back up a little bit and talk about the definition of disability. And when I say the definition of disability, I'm saying it in terms of what Social Security and Medicaid look at as a quote unquote disability. We've got the formalized definition of disability here on this slide. The key sort of things here are it's an inability to engage in substantial gainful activity, that's work, by reason of a medically determinable physical or mental impairment that's going to last for an extended period of time, okay? So the real crux of this, the question of disability is substantial gainful activity. You've got Christopher Reeve, who is an actor, Superman, and he was disabled after his accident. He was still earning a lot of money. So under the government's definition, he would have not been disabled for purposes of benefits. You have to be able to earn, the number is on the last little line there, it's $1,260 per month for non-blind individuals as of 2020. That number keeps kind of ticking up each year, and it'll change every year. But that is the baseline amount that a disabled person can earn in order to, I'm sorry, I shouldn't say baseline, that's the most a disabled person can earn per month in order to qualify as disabled. So if they earn more than that, and there are a few sort of caveats here because they will pull out some amounts of income. They just automatically disqualify $20, for example. But if you're around this 1260 number, then you're looking at, or less, then that is when you're in the SGA amount and you're qualified as disabled for this purpose. When we're talking about benefits, we've got two genres of public benefits. We have what we call the insurance-based benefits and the welfare-based benefits. So let's jump into those. Okay, so the insurance-based benefits are benefits where eligibility is based on an individual's work record, or as we'll talk about in a minute, on their parents' work record. And the insurance-based benefits, financial status is not relevant, okay? And the primary insurance-based benefits are Social Security Disability Insurance, also known as SSDI, and Medicare. That's as opposed to the welfare-based benefits where eligibility is based in part on financial status. And when we're talking about financial status, we're looking at income and assets. We're looking at income and countable assets, okay? And we'll get into that in a minute. What does that kind of look like? The welfare-based benefits are primarily going to be supplemental security income, also known as SSI, and Medicaid. So just to kind of pause, because sometimes people get a little confused. We'll back up. Insurance-based benefits, we're talking about SSDI and Medicare. These are the benefits where the financial status is not relevant, as opposed to the welfare-based benefits, which is SSI and Medicaid, okay? So to talk a little bit more about SSDI, like I said, it's either based on a person's work record, if that person has been working for a certain period of time, or it can be for a child who became disabled prior to age 22, and they can draw on a parent's work record when the parent dies, retires, or becomes disabled. We really need to switch up that phrasing there. It should say maybe retires, becomes disabled, or dies. But anyway, the point there being that, again, if your child is disabled prior to age 22 and you retire and you've been paying into the system, your child can draw on your Social Security record. Along with the SSDI benefit, again, the benefit that we're not worried about assets and income, along with SSDI comes Medicare after a person has been receiving SSDI for 2 years. So even if your child is under 65, if they've been receiving SSDI for 2 years, then they can also be eligible for Medicare. Okay, that's as opposed to SSI, which is a monthly income benefit to individuals who are either aged or disabled, and they're also impoverished. And SSI, like I've got on here, is that monthly benefit, and you get an income of up to $783 as of 2020. Again, just like the SGA income amount, this $783 figure will change pretty much on a yearly basis, and it always goes up a bit with inflation. When it goes up like, you know, somewhere in the range of 20 to 30 or so dollars at most. It's not a large increase, but it does raise each year. Okay, so in order to be eligible for SSI, you have to receive less than $783 per month in countable income, and you have to have less than $2,000 in countable resources. People are always asking, you know, what is a countable resource? What does that look like? So in Georgia, a countable resource is really anything that you can kind of get your paws on. So checking accounts, savings accounts, CDs, brokerage accounts, all of these types of accounts that you can easily liquidate, those are going to be countable resources that could disqualify your child from SSI. Likewise, or along the same vein, I should say, if you've got some kind of asset that is not easily liquidated, and by not easily liquidated, I mean very not easily liquidated, like a life insurance policy that's under a certain amount of money that your child owns. If it's a whole life policy, it could also be potentially a home place. If your child somehow owns a home place, things like that are not countable. With SSI comes Medicaid automatically. So when a person becomes eligible for SSI, they automatically receive Medicaid. And Medicaid also has the same requirements as SSI in that you have to have less than $2,000 in countable resources in order to be eligible. It's important to remember when you hear Medicaid, a lot of people, many of our clients that come in will just say, oh my gosh, no, we don't need Medicaid. We're not super poor, or, you know, that's not us. And we always encourage people to kind of pause and educate themselves, because Medicaid provides a lot of really valuable services to folks with disabilities, especially folks with developmental and intellectual disabilities. Things like transportation, housing, things like that, that they're not medical benefits you can get from certain Medicaid programs in Georgia. As I've got in this slide, Georgia has multiple Medicaid programs, and they all have different, slightly different eligibility requirements, but there's a lot of options. And I think a lot of people are unaware of a lot of the things that you can get with Medicaid. Part of the reason I want to emphasize that is because sometimes your disabled child may be receiving SSDI and Medicare, which, if you'll remember, are those benefits that we're not worried about the income and assets. Your child will continue to receive those benefits in any case. But maybe we also want your child to receive Medicaid. So you automatically receive Medicaid when you apply for SSI, but you can also have Medicaid without SSI. And so that's why it's important to understand all of the benefits that are available and make sure that you're not disqualifying your child from certain things just because you assume that, oh, well, we've already got some benefits, so we're good to go, or that's not for us, but instead realizing that you can have SSDI, Medicare, and Medicaid. Some folks, depending on their SSDI amount, could even have SSDI, SSI, Medicare, and Medicaid. So that's a complicated circumstance, but it can happen. It just depends on the amounts of money you get per month, and it's possible. So it's important to remember that these benefits, they're complicated and they can be confusing, but I think we always try to encourage clients to remember that the whole idea behind thinking about all of these things is that we want to maximize what's available to their child. Okay, so as I said, and as you're probably feeling right now, all of this is a little bit complicated, and a lot of times people don't even know exactly what benefits their child is currently receiving. When you apply for Social Security at 18, you get on SSI because your child is a household of 1 at that point. And, you know, assuming that you can stay on SSI for a little while and also receive Medicaid maybe, that child can rock and roll on SSI until a parent retires. And then Social Security will automatically roll that child into their parents' Social Security record. And so they'll send a letter usually, and sometimes people get the letter and kind of freak out, but I think most of the time people say, okay, and because it's a larger benefit, they just continue on their way. SSDI is often a larger benefit. But then you've just got all this shuffling, and a parent is like, whoa, what is my child actually receiving? I'm not 100% sure. So one of the best ways is to look at the Social Security statement, see how much is the check that you're receiving, how many checks are you receiving, and then also look to see if you've got a Medicaid or Medicare card. That is a pretty good indication that you're receiving certain benefits. For those of you that are receiving waivers or something like that, you're going to be very aware of what benefits you might be receiving, but you need to be very aware of how to keep those benefits at the same time. Okay, so that's a pretty good segue into our planning and talking about special needs trusts. So as I said in the beginning, special needs trusts are really meant to provide quality of life money for individuals with disabilities. It's not meant to be a trust that only pays for medical expenses or, you know, just the basics, medical equipment or any of that stuff, though it certainly can pay for those things. In order for a special needs trust to qualify as a valid special needs trust, the beneficiary has to be disabled according to Social Security criteria that we talked about in the beginning. And we've got to have this language that says special needs trust supplement but does not supplant public benefits. The idea with special needs trusts is that any funds that are going into a special needs trust are going to be supplementing benefits. So a trustee of a trust is going to first look to the beneficiary of the trust. They're going to look to the beneficiary of the trust's benefits, right? And see what benefits they're receiving. And then the trustee will supplement. So any funds that go into a special needs trust, that's allowable. So both the disabled person can put funds into a special needs trust and anybody else can also do that. And we'll talk about how that works in a minute here. The drafting and administration has to comply with SSI and Medicaid requirements. Important to remember that Social Security is a federal program, and so while it sort of operates a little differently in states, the rules are the same. Medicaid is a state-by-state program. So again, as many of you are probably aware, when a person lives in a state, and gets, certainly if a person lives in Georgia and gets Medicaid benefits, you're going to be hesitant to move because it's difficult to transition all that stuff because it'll change. So it's the same thing with the special needs trust. In Georgia, we're drafting our trust to comply with Georgia Medicaid rules. Just to kind of point out a few things about special needs trust, you can use special needs trust for travel. You can use the trust for, you know, a television, for, you can use them for living expenses, though you want to consider a few of the rules of Social Security when you're doing that. You can use the trust for virtually anything as long as it benefits the beneficiary, right? So if your disabled child who is the beneficiary of a special needs trust, that's the person that you can spend money on with trust funds. But you can send them on a trip, you can pay for a hotel, you could pay for a caregiver to go with them on a trip, all these kinds of things. Okay, so we have a few different kinds of special needs trusts. The first kind is a first party special needs trust, and I've got this AKA because you might hear some different phrases. So we've got a first party, AKA D4A, or self-settled special needs trust. This is a trust that's going to be funded by the disabled person's money, okay? So any money that the disabled person owns. And that creates a few limitations. So the first party trust is going to be a little bit more strict in how it's operated. The beneficiary has to be under 65 years of age in order to set up a first party special needs trust. A first party trust can only be established by a parent, grandparent, court, or legal guardian, or by the beneficiary themselves. And it's only funded, again, like I said, by the beneficiary's assets. It's got to be for the sole benefit of the beneficiary. And then maybe the crux of the first party issue is that there's a Medicaid payback provision in it. So because the first party trust is funded with the disabled person's assets, then Medicaid says, okay, we're going to continue to spend, you know, for you. If you're a beneficiary of Medicaid, we're going to continue to spend money on you, but we're keeping track. We're paying attention. And when you pass away, we're going to look for sources that we can reimburse ourselves with. And a first party trust is one source that the Medicaid can look for a payback. And so that's just part of the law. You have to include that provision in the first party special needs trust. Okay, so when does somebody need a first party trust? Not everyone needs one. You know, if you've got your 18-year-old child who has no assets to their name and they're not currently working, or maybe they're working but they're not building up a lot of money every month, which they shouldn't be if they're considered to be disabled, then they don't necessarily need a first party trust. The people who often need first party trusts are when you're in an accident and there's a personal injury settlement. If maybe a grandparent has gifted money or left money to a disabled person in a will, a grandparent or another family member, that can be a big issue. If someone has been working and building up funds and they're maybe, I've got on the slide, they become disabled later in life, but maybe they also were disabled, but they were still continuing to work and they were doing okay. But as they've aged, it's become harder. And now they can't work anymore and they have assets they've built up. And then for those who have gotten a divorce and you have a special needs child, that's often the case. You need a first party trust in that case when you're paying child support. But again, not necessarily for everyone. It can be, and it can also be something that you set up a little bit later in someone's life. So that's the first party trust. As the other kind of trust that we talk about is the third party trust. Okay, I skipped a slide. Here we go. Third party, inter vivos, or living special needs trust. When we say inter vivos or living trust, we mean a trust that you set up while you're still in life. And that means that you're setting up a legal entity that's going to be funded at some point in time. It can be funded when you set it up, or it can be funded in the future. And it's a legal entity that kind of controls the money. And again, anything that goes into that trust, be it parents' money, grandparents' money, friends' money, that's not countable for purposes of Social Security or Medicaid eligibility. So again, the deal with the third-party trust is that anybody else except for the beneficiary can fund it. Okay, so anybody except for the person with a disability can fund a third-party trust. There's no age restriction for a beneficiary of a third-party special needs trust. There's also no Medicaid payback provision because it's being funded with third-party money. So you as parents have been working hard to earn money and be able to provide for your children. So Medicaid says, oh, well, you shouldn't have to pay us back because this is your money. You can choose what to do with it. The nice thing about a third-party trust is that it can accept gifts or inheritances. So you as parents could set up a third-party trust, and if it's a living trust, then that trust can receive an inheritance from a grandparent or an aunt and uncle or anybody else who might want to also support the beneficiary. Another option within the sort of third-party realm is a testamentary special needs trust. So the difference between what we just saw, which was again the inter vivos or living trust, versus the testamentary trust, is that the testamentary trust is established under a will, and it doesn't actually exist or come into creation until the person passes away. So if mom writes her will and sets up a special needs trust in her will, then when she passes away, that's when the trust comes into existence. So it's only going to be available to be funded upon mom's death. In many cases, this is fine. It's not quite as ideal in Georgia because we have to get special needs trust approved by Medicaid. Any kind of special needs trust has to be approved. And when we do it in a will like that, it's just a little bit less set up, a little bit less. The infrastructure is a little bit less firm than if we did the living trust. But if you have a child with a disability, this is the bare minimum you should have, is the third-party testamentary trust. Another kind of special needs trust option that's really important to note right now, and if any of you were listening to Anna Maki's presentation with AAC last month, she mentioned this. It's the pooled special needs trust. Bobby Dodd has a pooled trust program that they work with, and then the other one in Georgia is called the ARC or the ARC of Georgia through Southeastern Trust Company. The deal with the pooled trust is that it's managed by a nonprofit in Georgia. Again, it's Bobby Dodd or ARC of Georgia. And there are other national pooled special needs trusts. You're not necessarily limited to those two, but those are the two that are kind of based in Georgia. The deal with the pooled trust is that the nonprofit organization pools assets of trusts, basically. And instead of writing a trust agreement, you write a joinder agreement and you join into a master trust. You can do this with a first party or a third party trust. And it works pretty much the same in that, you know, the beneficiary can request funds for whatever they might need. There's a little more bureaucracy involved because you've got a trust administrator that's through the nonprofit association. And you have to go to that person to request funds. That person doesn't necessarily have the same relationship with the beneficiary that an individual trustee might have. But it can be a really good option for folks who have less money to leave to their child, because remember, even if you have $2,000 or more, well, I should say maybe $2,001 or more that you're leaving to your child, you can potentially interrupt their eligibility for benefits, or they can lose their eligibility. And so we'll talk in a minute a little bit about kind of administering the special needs trust and what that looks like. We can go ahead and move on to that slide, I guess. When you're administering a special needs trust, you need a trustee who has what I call business common sense. So they are responsible with money. They know when to ask questions. They understand that they have some reporting requirements. A special needs trustee has to report to Medicaid if the beneficiary is on Medicaid. And they have to kind of be conscientious about how they're spending money. as I said before, the special needs trusts are their sole benefit trusts. So the trustee have to spend money for the benefit of the beneficiary. So if beneficiary is taking this awesome trip that I talked about, the trustee can spend money for a plane ticket, for a hotel, for eating out, any of that stuff. And they can even spend money for a caregiver to also fly, stay in a hotel and eat out if that caregiver is necessary to take a trip. They cannot pay for the whole family to go to Europe. It just doesn't work that way. So your trustee has to understand how they can distribute. Another deal, we talked about the vendor-based payments to distribute funds. Instead of giving the disabled beneficiary, you know, $1,500 to pay for their trip to Florida, or that's a nice trip to Florida, wherever they're going, the trustee will pay for items directly. So they would pay for the hotel, they would pay for the flight. If there are utility bills that the trustee is paying, they would pay the utility bills directly, things like that. So when we're talking, we go back to a pooled trust. And when you're thinking about who would be a good trustee, as a lawyer, it's a difficult question for me to answer because a lot of the times, really in an ideal world, we would have a professional trustee who's available to do all of this administration of the trust. But those professional trustees cost money. And the whole point of all this planning is to preserve the assets for a disabled beneficiary. So depending on how much money is going into the trust, a pooled trust would be a great option because it allows the beneficiary to continue having benefits, but they can also take advantage of funds that were left for them. And they don't have to just spend all the money down before getting back on benefits. And also they don't have to deal with the hassle of the bureaucracy of losing and trying to get your benefits back. If you can work with a professional trustee, sometimes that's a great option. Depending on your child's disability and the severity of the disability, sometimes an individual, like a family member, is really a great option because that child really needs a little bit of hand-holding or you know, a little bit of extra loving touch in dealing with these things, which can be very difficult. So those are just some considerations when you're thinking about who might serve as trustee. I briefly want to talk about the ABLE Act, although I'm not going to talk about it too much because Scott can touch on it too. You probably all have heard about the ABLE Act. It's been out for a few years now. The ABLE Act is modeled after 529 college savings plans legislation. And so it's got some tax savings in there. It's marketed as a really awesome thing to save money and invest money that belongs to a disabled individual. It's a fabulous tool, but we always kind of try to emphasize that the ABLE account is just another tool in your special needs planning toolbox. In order to establish an ABLE account, you literally go online, or you can work with someone like Scott to help set one up. You have to be disabled prior to age 26, and you have to be able to substantiate that disability with some medical documentation and evidence. It's not just the kind of thing where you can say, they're not, so I will say this with a caveat, they're not auditing these ABLE accounts very much yet. And by they, I mean the IRS or Social Security. They're not auditing these accounts too terribly yet. But what we have heard down the pipeline is that it's important that you be able to substantiate the disability, which is not necessarily the case with special needs trusts. As a lawyer, I'm not going to prepare a special needs trust for someone who I don't feel, you know, is a disabled beneficiary, but it's just a different, it's a slightly different sort of, it seems to be a slightly different level of substantiation that's required. You can only have one ABLE account. That's not the case with trusts. You can have as many trusts as you want. That's not necessarily recommended, but that's the deal. And ABLE accounts have to be used for qualified disability-related expenses. Now, what does that mean? I don't know. Certainly for someone who has autism, a qualified disability-related expense could easily be a trip or some other social engagement, or maybe a massage or some kind of physical therapy. So as long, again, as you can substantiate that, that doesn't necessarily mean it has to be a medical expense. But they haven't really given us a definition of what that means. The other deal with ABLE accounts is that you can only contribute up to $15,000 per year, plus a little bit more if the ABLE account beneficiary is working. So you can contribute, oops, let's see, I've got my security there. You can contribute a little bit more if you're contributing income from the disabled person. The other biggie on ABLE accounts, and one of the reasons why I don't think that ABLE accounts are a replacement for special needs trusts, is because they have a Medicaid payback provision. So when we're talking about saving tons of money or investing money in ABLE accounts, you gotta be really careful with that, because you could be putting that money into a trust, potentially a third-party trust if it's third-party funds going into the ABLE account that doesn't have a Medicaid payback provision. So that's an important thing to kind of remember. I've got some just sort of comparison slides here. I think I'll let you look at those. There are some things I will point out on this slide in particular. For those of you that are receiving Social Security, you'll be familiar with ISM payments. And if you'll look to the middle of this slide or so, ISM is in-kind support and maintenance. And if you're receiving SSI, what that means is that the beneficiary has to use their SSI payment each month for food and shelter. And if someone is providing them food and shelter, in addition to their SSI payment, then that person will get a reduced SSI payment. Something that we're really excited about is that with ABLE accounts, if the food and shelter is paid out of an ABLE account, then you don't get a reduction for ISM payments. Whereas you do if you're using a special needs trust. So that's kind of an exciting thing. Another thing on this slide to kind of note is that we haven't gotten there yet because ABLE accounts haven't been around long enough, but the first thing here at the first point under ABLE accounts is that ABLE accounts can only build up to a max of 100,000 before benefits are paused. So 100,000 for Social Security and then it's paused, and 235,000 and then Medicaid is paused. That could potentially change a little, but I don't see it changing a lot. So that's not a good thing. And I don't necessarily think ABLE accounts are the best place, though certainly it's an individual situation, but they may not be the best place to build up funds, but instead they have a lot of other uses. Okay, so with that said, that's kind of my portion, and I will stop my share and let Scott jump in.
Okay, great. Thank you so much, Laura. And Scott, before you get started, I just want to remind all of our attendees that while your microphone is muted, you do have access to the chat box. If you're unfamiliar where that is, if you look at the bottom of your screen, you can ask all of your questions there in that chat box throughout the presentation, and we will be doing a Q&A with our panelists after. All right, Scott.
Okay, I'm here. Can you hear me?
Yes, absolutely. Are you able to share your screen on your side?
No, I just got the same thing that Laura did.
No problem. We are going to figure that out right now. So I know that we were having a little bit of technical difficulties with that. So let me just switch this. And Laura, you may need to do it on your end because since we had that disabled for some reason. Oh wait, nope, I figured it out. Never mind, Scott. I'm your way. We are figuring this out as we go. All right, Scott, you should now have no problem sharing your screen.
Yes, looks like it's working. Okay.
Perfect. Thank you.
See if I can pull this off. I am not as tech savvy as everybody else. Let's see if I can find my presentation now. There we go. I'm still getting used to talking to my computer and not a live audience, so I'll do my best. Love talking for you guys. I'm glad to help. Like Laura mentioned, I am a parent of a child with special needs. My son has Down syndrome. When he was born in 2005, I realized I didn't know much about my financial planning situation, how it's going to change with when Jake was born. So I started on this journey to learn, and I ended up hooking up with a lot of attorneys, people like Laura, to find out what should I be doing and what's different. So this kind of became my mission, and I really enjoy working with families like mine because I have a lot of the same questions that most people have, which was, Things like, what financial concerns do you worry about the most? That something I worry about every day is what's going to happen to Jake when I'm gone. And that's not going to change. But one thing that we can work on is the financial issues and make sure that our kids are taken care of financially when we're gone. Number one thing, it's never too soon to start planning. Most of us have seen different statistics on starting investing as a young person. You can start saving a very small amount of money when you're in your 20s, and it can turn into a lot by the time you're in your 60s and 70s, and that never changes. The earlier we start, the better. You can manage this process in phases. Most families are, they're overwhelmed with young kids. It's hard to get saving and investing when all life is in the way, but just get started doing something and we'll ramp it up along the way. You're going to have a team. So your financial planning team really is going to consist of a couple different people. You're going to need somebody like me, an advisor who understands investments, insurance. You're going to need a government benefits specialist. After listening to Laura, I'm sure all of you guys are saying, holy cow, I need somebody to help me with this stuff, to navigate the different types of Social Security. And a lot of parents get really good at it and figure out how to do it on their own. It may be through an association like this that you're going to learn these things on your own, but there are people that you can hire to help you with these things. Last, you definitely need an attorney to make sure that your plan is tight. The last thing you want to do is leave some money or put some money in your child's name and disqualify them for some benefits that they're entitled to and they may be using. Things that I help you with is, let's try to understand, what are your savings and spending habits? Are you a saver or a spender? What are your short-term, medium-term, and long-term financial goals? And what are your dreams for the future? I have people that tell me they want to live in their same house for the rest of their lives. I have other people that tell me they want to retire at the beach, and we need to plan accordingly. And then on the right-hand side, we got to plan for your loved one. What is your vision for your child's life? So like with my son, I certainly hope he lives very independently. I would love for him to get married and live with his wife somewhere. Where will that be? I don't know. He's 15. Can he live independently? Can he live semi-independently? I don't know. But these are things that we have to prepare for and plan for the different alternatives. Who will provide for their day-to-day care? Will it be me? If I'm going to live at the beach, can he live in Atlanta and still be taken care of? I don't know. And what are they going to do socially? When Jake is out of school, which I've learned a lot of over the last 3 months, is what are we going to do with our day-to-day activities? This COVID thing has really made it obvious to me that when Jake is 22, 23, and he's out of school, I need to make sure that he has a very active social life and hopefully a job. But these are concerns and things that we have to plan for, though. Get the benefits that your loved one may be entitled to. I'm not going to talk in great detail about these because Laura just did. But let's go through just the basics. The top category is Social Security, SSI, and this is a welfare-based benefit. So when Jake turns 18, we're going to apply for SSI because it's going to be based on his work record. Now, occasionally parents will get SSI for their child before they're age 18. It's pretty rare because they count your parents' assets, and that's down at the bottom. Most of the time, parents' income and assets disqualify them, but occasionally they do qualify. But when Jake turns 18, I haven't put any money in his name, so he should qualify. His assets will be below, and he'll get the, as Laura's slide updated my number, it's $780 something a month in income. And then retirement. One day I'm going to retire. So when I reach full retirement age, Jake is going to get an increase in his Social Security check. So he's going to go from SSI to SSDI, and he'll start getting more money. And this is really where the rubber hits the road for my end of the planning, is that we try to attempt to estimate future costs. We look at, where are you going to live? Where is your child going to live? And let's figure out what's that going to cost on a monthly basis or an annual basis. And then we work together to make sure we have enough money to meet the gap between government benefits and what you guys need. $783 is not a lot of money on a monthly basis. And that is definitely not going to be enough for my son to live the lifestyle that I want him to live. So we have to plan and save for that. make sure we have an attorney to put together the trust for you. Trustee, I'll just touch on that because Laura talked about it more extensively. This is what we see in the real world is a lot of times people choose a family member as a trustee. Sometimes you'll have a corporate trustee like a bank. Sometimes you'll have co-trustees where you can have a family member and a bank as co-trustees. You can have two members of your family as co-trustees. Don't necessarily recommend that because they have to get along and agree. But these are some of the things to consider. Jake, my son, with his trust, right now the trustee is me because I'm alive, so I can take care of it. If I'm gone, his mom's a trustee. When we both are gone, that's where it gets a little dicey, and that's where you guys have to start thinking a little bit deeper about who would be the trustees when you guys are gone. A lot of times it's siblings of the beneficiary, but right now some of the siblings that you may be considering are kids themselves, so you have no idea of knowing who's going to be the best trustee. That's why it's really important when you work with somebody like Laura is to, you guys will have to dig deep to figure out who some of these people are that could be serving as a trustee. And another reason why a corporate trustee is oftentimes advised, at least down the road, to be a remainder trustee. So the financial plan that we put together for families, it really includes the whole family. If I'm working with a couple and they have a child with special needs, I mean, the first part of the planning is to make sure that the couple is financially secure. So we're going to help you guys save for your financial security, but we have to factor in your child as part of your plan. This is a basic example. If you wanted to retire at age 65 with X amount of income for yourself, we're going to factor in that, but then we'll also add the extra additional money for your child. If, in my case with Jake, I'd like for him to live somewhere else. Now, he can live with me, that'd be great, but if he wants to live independently, and I hope he has the capability to live independently, I have to budget for that. And that's where it gets tricky, and that's where the numbers just get a little bit bigger, right? If we're planning on funding 2 households, even if we get creative, there's going to be extra expenses, and we do have to plan and prepare for that. ABLE plans. So Laura touched on these. These are definitely new. They can be exciting, but they also have some limitations. Where I see them being really practical is when you have a family with a few kids. Like a lot of my clients will have some typical kids, and then they'll have a kid with special needs, and they're saying, hey, I'm putting money in these 529 plans for Joey and Johnny. What can I do for Jenny? Well, these ABLE plans are a great way that if you wanted to save a couple $100 a month in a place that's going to grow tax efficiently, these ABLE plans can be a good place to put some money. The money grows in there tax-free, which is nice. And you have some flexibility in how you spend it. A lot of these ABLE plans come with a debit card. So like with my son, he's got an account and we got a debit card. So when he's a little older, a little more responsible, he'll be able to use that debit card and spend money himself out of his own ABLE account. But as Laura said, some of the limitations, the big thing is $100,000 or less. So this is not going to be an end all to your financial planning because most of the time our kids need a lot more than that when we're saving for the rest of their lives. And plus you can only put in $15,000 a year. So it wouldn't serve as an inheritance vehicle, right? If you were going to leave your balance of your 401k to your kid, you can't put it in an ABLE plan. But if you did have a grandma that wanted to give your son or daughter $5,000, why not set up an ABLE plan and put the $5,000 in there and let that money grow tax-free? Just know that there's that Medicaid provision, which makes things a little bit different, right? With financial planning, generally when we put something in a vehicle that the money's going to grow tax-free, we tell you to spend that last. In the case of the ABLE plan, that's not necessarily the same, right? Because we don't want Medicaid to get the money. So we would rather you spend this first, because then your trust money can go on to your other children or other beneficiaries that are important to you. That's really all I have for here. But the big thing is, the big questions that I get for people are, how do we fund a special needs trust? And what is the reality of what money goes into the special needs trust? Well, it can be anything. And most families, it's their retirement plans, their IRAs. They plan on using it for their life, but when they're gone, they name the trust as a beneficiary. Life insurance is clearly the biggest asset that most people name to to their special needs trust, and they just direct it through their beneficiary arrangement. And why life insurance is because you use pennies and it turns into dollars when you die. It's tax-free benefit that's going to go right to the special needs trust exactly when you want it to, is when you guys are gone. So what we do is we look at your financial plan and make sure you save enough money for your retirement and the retirement of your loved one, and that there's enough left when you guys are gone to fund that special needs trust. All right, I guess I'm done here, so we can share screen somehow.
Okay, great. Thank you so much.
Stop share.
That was fantastic. Okay, everyone. So now we are at the portion of our program where we are opening it up to questions and answers. Just a reminder that your microphones are muted, but you can ask any questions that you have in the chat box at the bottom of the screen. And I'm going to go ahead and get started for Scott and Laura. We do have one question that has come through. This question is, my husband and I are updating our wills and need to appoint a legal guardian after our death or incapacity. We have no family who can do this, so I wanted to know how to find a suitable guardian for our disabled son.
So I can kind of jump in on that and say, frankly, that's a very common question with a very difficult answer, because there just aren't that many people who are there. There are professional guardians you can hire and engage to do that kind of thing, but they're very few in Georgia, at least. Siobhán, just as a side note, it says you've paused my video. I'm happy to not be on video, but I'm happy to be on.
Oh, no, it's up to you guys. I normally just pause everyone unless you guys want to have the video back. So I'll give that back to you if you'd like.
Sometimes it's nice to have a face with a name. Anyway, so, but the bottom line is that my advice to clients is, before you totally nix family or friends as guardians, think about it a little bit more. And then my other thought here is that I'm actually speaking next month on guardianship, and I would suggest that person listen to that presentation, because I do wonder if, after hearing a little bit more about what's involved, that a person might be a little bit more, it might open your mind a little bit more. There are some professionals around Atlanta who can do it, but I don't think that's the best option because they're expensive.
Okay. All right. Thank you, Laura. Our next question is, I'd like to know more about what counts as a qualified disability expense for ABLE accounts. If my child has a debit card, can they spend with it pretty freely?
Tricky question. As Laura mentioned, that the definition has been, it's pretty liberal, is my understanding. I mean, you can Google it, you can look it up, and you can look at the various websites for the administrators, and none of them really gave a clear answer. My understanding is you can pretty much spend it on anything. And with the debit card, the examples that the people gave to me who were speaking on their personal plans were, you can limit how much money they can spend, which I thought was really cool. If you have a son like mine who loves to eat, you can say he can't spend more than $20 at a restaurant. And there's some safety into that too, where our kids can't get taken advantage of when they're a little older. We don't want them, paying for all their buddies' stuff with being taken advantage of. So you can put limits on it online. You can also eliminate certain stores. Like if one of your kids has a problem going to whatever store and spending money, you can make that place not eligible to take the debit card. So there's a lot of flexibility for the parent to build in how your kids spend the money. But my understanding is they can spend it on pretty much anything. Laura?
I'll add to that. I mean, I think that's essentially my understanding too. Like I said, they're not auditing ABLE accounts yet. So if they ever do, the key to the qualified disability expense limitation is that you would have to be able to substantiate. So again, if you're spending on clothes, to me, that's a no-brainer. You need to be able to clothe your child, right? Things that are a little bit more iffy, like a trip, you would just need to be able to explain, well, my child has these certain needs, and here's why a trip would help them. But so whenever you're spending out of an ABLE account for something where you're like, well, I don't know if this totally counts, I would just document it.
Okay, great. Our next question is, where or how do we sign up for an ABLE account?
All right, there's a couple popular plans. In Georgia, these plans are administered like other 529s in that they're state administered. So Georgia has a plan. They've actually partnered with the Ohio plan, but you can go online and Google this, and I'll also type it in the message, but it's the Stable plan. So if you go to Georgia Stable, STABLE, if you just Google that, you can pull up the website and you can set it up online yourself. Very simple, very easy. You don't work with an advisor to do that. Now, as far as advisor sold programs, there is one with the American Funds that I can help you with. It's out of Virginia. It's a great plan. If you're working with a financial advisor, we can help you with that, or that advisor can help you.
Okay. Our next question is, my son is 17 and will be 18 in September. If we haven't really started making some of these plans, what is the first thing we should do?
Scott, you want to, I'm happy to contribute to that, but again, I don't have a child with special needs, and I have thought, I guess I'll say my thought on that question is either meet with someone like Scott or someone like me to get a game plan. And then there's a lot of different things that you can do to take steps moving forward. But I think meeting with someone who knows a little bit about all this stuff will open a ton of doors for you. And then you'll have to kind of prioritize what's the most important based on your situation. Not to put a plug in for us. I mean, there's a lot of different people that you can meet with. I don't necessarily mean just me or Scott, of course. There's a lot of people in Atlanta, but I would say find somebody who knows the deal with disability benefits and money, and start thinking about talking to them.
Okay, I'll jump in there. You're at a pivotal age, because when your child turns 18, that's when you guys are going to be applying for SSI, assuming you haven't gotten any of these benefits yet. So I would want to make sure that you met with somebody sooner than later, just so we can make sure that your balance sheet's cleaned up. So if your child has any money in their names, you need to spend it now. You need to get it out of their name, because when you apply, they will not qualify because of those assets. You'll want to go through all of your beneficiary arrangements and make sure that those aren't going directly to your child, because if something were to happen, that money would be theirs. So you really do need to meet with an advisor and an attorney sooner than later and get started. I would make sure that you have adequate life insurance. Those are things that get started right away. Bump up your life insurance. That's kind of easy. And look at your savings. You'll want to increase your savings most likely.
Okay, well, that segues nicely to our next question, which is, if you have a trust set up in your will, should you put some funds in it prior to your death?
So if you have a trust set up in your will, that's a testamentary trust, and you can't put funds in it prior to your death because it doesn't come into existence until you pass away. If you want to fund a trust prior to your death, you have to set up a living trust or an inter vivos trust. You can't do the trust that only comes into existence in your will.
And you don't have to put a lot of money in it. I think that's one of the big misconceptions about when you set up a trust. A lot of times parents are thinking they've got to put money in it now. You really don't. I think when I set mine up, I put $500 in it just to have an account. It was a receptacle and it was ready there to receive money. And sure enough, 9 months after I set it up, I had an uncle pass away, and he included Jake in his estate, and Jake then got $10,000 that went into his trust. Because I had it set up, it was ready to receive money when that time came.
Wow, that's really great advice, Scott, because I don't know that all of our parents on the call tonight knew that. So thank you for sharing that personal story. Our next question right now is, I will have to decide between allowing the court to appoint a successor guardian or finding a professional guardian. There is no family. What is your advice?
So kind of going back to what I was saying before, just saying there is no family, and maybe there truly is no family. Are there any friends? Are there other people involved in that person's life? And then again, there just may not be. That is the unfortunate reality for a lot of people. When you're talking about a court-appointed guardian versus a professional guardian, I don't want to do a cliffhanger exactly, but we'll talk about all of this next time. But you're talking about a state-appointed and funded guardian versus a guardian that's funded by your funds. And so the first question is, can you afford a professional guardian? And then the second question is, what kind of needs does your child have? You kind of have to evaluate based on those things. That's a super tough situation to be in, and there are options, and it just depends a lot on the circumstances.
Okay, great. Thank you, Laura. This next question has a couple different parts. My daughter and my husband are both diagnosed with autism. My husband is the breadwinner and didn't get diagnosed until last year. My daughter is 3.5 and was diagnosed last year as well. I have been her caregiver, and I was about to start working on getting her the Katie Beckett waiver before the pandemic hit, but now my husband and I are getting a divorce. Is there anything available to me to help her with her special needs? And if I do end up getting her the Katie Beckett waiver, will it pay for the services that my daughter received retroactively before receiving the waiver? Also, what is the best way to get the waiver during the pandemic?
So the Katie Beckett waiver will be a great, assuming that your daughter qualifies, it would be a great source. The Katie Beckett waiver is, for those that may not know, although maybe everybody does, but it's a Medicaid program that will pay for certain children who are usually a little bit on the higher need level of things. And it will pay for somebody who's under 18. So it's one of the only Medicaid benefits in Georgia that will support a beneficiary that's under 18. I don't think Katie Beckett has retroactive coverage, but I'm not 100% sure about that. I will say, first of all, there's another program called Babies Can't Wait, and I believe that program stops around age 4. So that would be a good place to start in Georgia as far as getting support for application to Katie Beckett. And there's another person, and I'm literally at my work computer, but I've got a laptop up. I'm going to pull up the other person. As I'm sure many of you are aware, there's just not a lot of support right now for these kind. Our firm, for example, we don't do Medicaid applications, but there are people who do them. Let me see if I can find this person's name, because I don't typically like to just necessarily give out one.
I just jumped in one that I know of, Debbie Dobbs. She speaks at a lot of organizations, and I've seen her speak, and she definitely helps parents put together their applications.
And so she is
that someone who you might want to point people in direction to, Anna Maki with Bobby Dodd for this?
Anna Maki doesn't do that age, and they don't. I mean, they will do Katie Beckett, but not that young. Bobby Dodd starts working with kids usually when they're around 6 or 7.
Okay.
And I was looking at the other person because we've started connecting with this person, and we've had pretty positive results from clients. And I can't find it now. I can send it to Siobhán, and she can send it out later. But the deal there is, I would encourage you to the bottom line, and all I'm saying here is, I would really encourage you to start that process, because it's a little bit lengthy and it can be difficult, but it can be a huge support if you can get it. And it's well worth the time to try to get it, even though it's really frustrating.
Yeah, and also say that she can do it herself. I mean,
Yeah.
a parent just put that in there. Be careful. Some people overcharge you.
Yeah.
You can do it yourself. Most people do it themselves. It's not that complicated, but if you want somebody that has done this before, they'll charge you, and they'll get it through the goal line. But you can do it yourself. I think the question is really more in reference to during the pandemic, and I don't know if these offices are open. I think that might be the bigger issue, but you can do it online. And I think the last time I had it for Jake, I printed all the papers online, filled them out, and I walked into the Medicaid office and turned it in myself.
It's not difficult. It's just very, very exhausting, and you often have to fill out things kind of back and forth. I'm glad to hear that we've got some positivity from Debbie Dobbs. The other thing just to remember, if you are going to other resources, is to kind of do your due diligence. As the one person noted, that some people are taking advantage of these types of things, and you want to make sure that you're kind of looking over their shoulder a little bit and making sure that they're doing what they say they're going to do, because we have had some people who have been frustrated with that kind of thing.
Absolutely. Great advice. And just so everyone on the call knows, for all of our attendees, we will be sending out information after this webinar. That also includes the contact information for both Laura and Scott in case you have any specific questions directly for them. And Mrs. Collins, I see your question right now in the chat box about guardianship. For everyone on the call tonight, if you have not seen our announcement about next month's event, it will be about guardianship and conservatorship. We will be joined by Laura again for that as well. So for everyone who has not received that information, we will be sending that out to all of you too. Okay, do we have any last questions before we wrap up tonight? All right, well, I just want to thank Laura and Scott. Thank you both so much for giving of your time tonight and being part of this program. Thank you to all of our attendees. We are so glad that you were able to join. And if you think of any last questions that you want to send our way, I will be including my contact information along with Laura and Scott's in the email all of you will receive after this event. Laura and Scott, any last words?
No, I appreciate everybody listening and being involved.
Nope, thanks for letting us talk.
Absolutely. Thank you guys for being such a wonderful resource tonight. Wishing all of you a wonderful rest of your evening, and we look forward to seeing you in July for our panel on guardianship and conservatorship. Thank you guys so much.